just like it sounds.
I worked in E,
I think
but
it's
You know, that would not surprise me with you guys, but overall, I'm shocked. The Carlos Valson, is that you, sir? Well, I guess we, where to begin is, should be the title of this one, Ben. How many cases are there? At your
Only one-
life?
only
No,
one,
I'm
but-
asking you, I'm asking.
I'm sorry,
It's a
Judge.
rhetorical. How many are you? How many? It's like you're guessing.
Like
You certain?
my whole life on it.
Is this, yeah, this is the story of your life. Certainly a big chapter of it. Too many. I seldom, doing this for a long time, seldom as one person accumulated this many charges in one setting, for one setting. I would say the moral of the story is quit making mistakes, which you know have consequences to it. All right. There's 9. And you have pleaded guilty in each of these, and we'll move forward quick enough here. 24 CR 992. This is evading detention with a motor vehicle, and it is a second-degree felony punishment. It was a third-degree felony, but you pleaded true to paragraph 2, which is a prior conviction. So you have the evading detention with a motor vehicle, a third degree, and then aggravated assault in 2011 out of the court next door. So in that case, you're looking at really the full range of punishment, no less than 2 nor more than 20 years confinement in prison.
Judge, I apologize for interrupting.
Yeah.
But I want to make sure. I heard a different cause number. Can you repeat what cause number we're on?
22-39938 is
Thank you,
what we're
Judge.
starting with.
Thank you, Judge.
And you're looking at no less than 2 nor more than 20 years confinement in prison. You could be placed on up to 10 years deferred or unadjudicated probation. And also here, I think you can be sentenced to no less than 2 nor more than 20 years confinement in prison. And then if it's no more than 10 years in prison, I have the option to suspend the sentence and place you on regular probation. And it's my understanding all of these other cases, which we don't need to get into, will be dismissed as part of this agreement. Is that right?
Not at all, Judge.
No. See, here's the problem is I refer to the front of the jacket and there's nothing that's showing that he pleaded guilty to any of these. So
The defense opted to wait to see what you do before they decide what to do with the 8 cases.
these are just held in abeyance.
Yes, Your Honor.
He hadn't pleaded guilty to them.
No,
No.
this was set for trial on the evading.
Yeah.
We pled to the evading, what it's called.
All right. So let's just focus then. There are 8 other cases pending, but the most relevant one is this one here, evading detention with a motor vehicle. Also, it goes without, it doesn't go without saying that there was a third paragraph in this indictment which alleged that you were convicted of a felony of illegal possession of a controlled substance in December of 2021, which was committed after the illegal possession of a controlled substance, the 2017 conviction that's in paragraph 2 that I'm sorry, that was after paragraph 2, aggravated assault, deadly weapon, that you pleaded true to. But also there was another prior conviction in 2017 of illegal possession of a controlled substance, and then a controlled substance in 2021. The point is that This indictment included not only the third-degree felony of a new offense of evading arrest or detention, but 3 prior felony convictions in sequence: a 2011 that you pleaded true to, 2017 illegal possession of a controlled substance in this court that you were convicted of, and also thereafter you committed the offense of another controlled substance offense and was convicted of that out of Chambers County in 2021. So that you, to show you where you stand on your criminal history, which is poor, is you have been a subject to being a habitual felon offender 2 convictions ago. Oh, so your criminal history is not good. Let's see the circumstances of this case we're going to talk about. The pre-sentence report was prepared and distributed to the parties. Have the parties been able to review it? Any corrections or changes to it?
Defense has and none.
And state.
We've reviewed, no changes to it.
It's made a part of the record for all purposes. Okay. I'll go ahead.
I call DeCarlos, Your Honor.
right.
He's been sworn in.
Yeah. Raise your right hand, the other right hand, sir.
Oh, yeah, my bad.
There. You solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. Lower your hand.
Yes,
Okay.
Yeah.
Listen
Please, court.
carefully, answer truthfully.
For the record, could you state your name, please?
DeCarlos Belson.
And DeCarlos, you're here in front of the court in which the judge has to decide what to do with you, correct?
Yes, sir.
And that he's given you all the options that possibly could be. But let's get this on the table because it's all set out in the PSI report. You started when you were a juvenile, correct?
Yes, sir.
And back then they called it TYC, and you've been to TYC a couple times, correct?
Yes, sir.
And that was for burglary of a vehicle and possession of controlled substance, resisting search, things like that, right? And then when you got out of juvenile, you've gotten also in trouble, correct?
Yes, sir.
And in fact, it probably takes up 2 pages. Well, actually more than 2 pages. Well, page and a half of adult, page and 3/4 almost of adult, not including your convictions, which include misdemeanors and felonies. In fact, there's 1 page of felonies, correct? That you've been in trouble for.
Yes.
You're 32 years old, correct?
Yes.
How long have you been in custody for? I mean, how long have you sat in jail in your life out of the 32 years? Do you ever add that up?
15.
How many?
15.
15 years, so almost half your time or half your life. Now you've been sitting behind bars, correct?
Yes, sir.
All right, and now you have pending not 1, but 9 felonies. Most of them, besides this, are possession charges, drug charges, right?
Yes.
Tell the court why, in their right mind, they would even consider giving you probation, either deferred or late. Why? Why now? After you spent 15 years of your life? What's changed? Speak up.
To be honest, old enough, married, I've newborn, I just learned how to change diapers and stuff like that. And I realized it's more to life than just, committing crimes all the time. I got a family, been having a family, but, I got an immediate family now who needs me. I've never been on probation either. I've never even had probation. I was juvenile or adult.
What's the point you're making about that?
You know what? Why
So
now
what?
are you reaching out for help, saying, "Let me show you what I can do"? The last time that you were arrested was January of this year for 3 felonies of possession of controlled substance. I guess that was before, or was that about the time that you moved on?
The day before.
The day before. Did you realize that you were having a child? But you got arrested. Okay. after the child was born, and I want you to talk about why now probation, but what has changed after, you had a child? Was it a boy or a girl? A girl, okay? And do you all live together?
Yes, sir.
And are you married?
Yes, my wife.
Your wife's sitting right back there, okay? What would happen if, let's just say 18 years from now, your daughter's standing up here facing 9 criminal charges? How proud would you be?
Wouldn't be proud at all.
Well, I mean, you got to talk to the court. How about your record? Not very good, is it? So why now? And this is what the court wants to know. Why now should he consider probation, even though you haven't had probation in all this time?
Just feel like, really not,
You speak up, please, so she can hear you, sir. Thank you.
I just feel like I can do it now. So, like I said, I have a family, and I would like to be there, for them, be able to help, try to get on the path, do the right things. Successfully completed if it was given to me, successfully completed. Not just show anybody else, to show myself that I could do it. That I can be in society without, committing crimes or anything else like that.
The reality is that you probably not do much time on a 20-year sentence.
Objection. That's a statement, not a question.
Well, it's part of the parole law, Judge, that's been given every time a jury gets a punishment. And I think that it's a great question, because my follow-up question is why not just take the jail time and be over, instead of having something over your head for the next 10 years in front of this judge?
But I'm learning to take responsibility for my actions. So either way, I have no choice either way, but I would prefer to do it, but I have to do what I have.
What have you been doing since the last arrest in January of 2020 to better yourself?
Working, I'm taking care of my.
Where are you working at?
I was an electrician today, laid us off, and having jobs, but I just been getting me sick, so I've been looking like every 2 weeks. I've been getting me sick. So I'm taking care of my daughter.
You were what, an electrician?
Yes. Take care of my daughter. The family, getting in the house, the kids, going to football practice and stuff. My stepson, stuff like this. Now I'm trouble.
What child is at the house that you have to go to football practice for?
My stepson.
Your stepson.
Stepson.
How old is he?
8.
Well, what kind of example are you setting for him?
It's not a good example. But since January, I've been showing a great example. Just look at my life before that. Very bad thing.
What are you asking this court to do?
Show me favor. You see, just I would love probation. Also, I want to get over it.
I pass the witness, Judge.
State gets to ask you some questions that they will.
As to this last conviction, the offense alleges that it's January 20th of 2017. That's an offense for possession of a controlled substance. It says that you were sentenced on November 17th of 2017, and that you received a 7-year sentence. That would have been out of the criminal district court in front of this judge in cause number 17-27189. Is that offense true? Is it correct that you received a 7-year sentence? Mathematically, that means that if you served the full 7 years, you would have been in prison whenever this offense was alleged in on April 19th of 22. You agree with that statement? But you were out. That means you were out on parole, yes? Now that parole would have continued all the way up until November of 2024. Mathematically speaking. So are you still on parole, sir, is my first question. When did that parole get discharged?
Last year? Early. I don't really remember, but I've been off the road for a while.
You understand that the type of thing that you're asking this judge to do is very similar to the parole conditions that are done once an inmate convinces the parole board that they're going to be released. They're released on rules and regulations very similar to probation. That means that you just admitted that you couldn't do that. You violated that. Are you going to admit or deny that you are responsible for the possession of controlled substance, the delivery of controlled substance, 3 counts, so 4 different offenses on February 5th of 2023?
Your Honor, at this time, I'm advising my client not to acknowledge that until the cases need to be addressed.
All right. Then, are you objecting?
I'm objecting,
Okay,
Judge.
then
They're going to be
sustain
taken care of at a later date, but at this point, we don't know what will happen.
Are you going to take that same position, sir, about the 3 possession charges from January 6th of 2024?
He's not taking the position. His attorney is advising him to take that position.
I'm asking you
But at
then
the
the
end of
same
the day,
question,
it's his
sir.
choice.
It is, Judge. And, but we're here.
That's semantics. You're going to object and I'm sustaining.
All right. Do you realize that you were out on bond on clause number 223938? Right? That's true. You were out on bond. Yes. You didn't come from custody. You were out on bond, right? And it is true that you had conditions that said that you were not to break the law. You understand that that was a condition of your bond. Yes. And you will admit at least that you were arrested for 5 different charges that alleged to have occurred on February 5th of 2023. That you were arrested and charged. You know you're under indictment for those matters. So you'll go that far. Additionally, that is true for the other 3 charges from January 6th of 2024. Now, sir, am I accurately stating that whenever you were arrested and charged with those 5 offenses from February 5th of 2023, that you made bond and you got out and you were released again? You had an opportunity to make choices then. Same thing occurred whenever you were rearrested on January 6th of 2024. You had an opportunity to make choices. Again, you were at a point in which you needed to either follow or not follow conditions, right? But you were released in that regard. In the PSI, sir, it states on page 5 that you admitted to being a member of the Bloods. Is that true? You also told that officer that you've been committing crimes since you were 13. You are how old?
32.
13.
In addition to the other pending charges, you as well have pending misdemeanor charges for possession of drug cases. Different drugs, right? Do you have a drug problem?
Oh, sorry.
Do you have a drug problem? Or were you just selling? Do you have a drug problem, sir? Or were you just selling drugs?
Objection as to the question, Judge. That's 2 questions. He
Do-
has a drug
I will break
problem.
them
That's
down.
1
Do you
question.
have a drug problem?
Is that, you can answer that.
Well, I did. I mean, I wouldn't say I have it now. Like, no.
So as you stand here before this judge, before he makes a decision, your final answer on that is you don't have a drug problem. I'll delay the other question, Judge. I don't need to ask him any further questions.
Go ahead.
I have comments, Judge.
Yes.
You can give him the 20 years. There are 8 more cases. There are several options here. One of them, as outlined in the PSI report from the probation officer, is that if for some reason you were considering probation, and there are some options in reference to that, that he be given ISF Then after that, he'd be given moral recognition therapy. He'd be given behavioral educational program, and of course, defensive driving, because that's why we're here today, because of his driving. The option, Your Honor, is a couple. As I said, 20 years, and you can calculate what possibly he might be out on. You could put him on probation. You could, he's already pled true to one of the enhancements. He could plead true to the second enhancement and would give him a baseline of 25 years if he screws up. And put him on for 10 years, 25 to life. Along with that, Judge, you could possibly consider a jail time, though he's been to jail before, and put him in jail for one of the drug offenses or two of the drug offenses, either the state jail or TDC, and then continue probation when he's out. Now, he doesn't have the record for those considerations, but being his age of 32, and it doesn't seem like it's slowing up, that would probably put him into his mid-40s before he comes out from under the supervision. Plus, in addition to that, though, Judge, is that if he screws up, he's looking at a minimum of 25, and he'll be in front of you probably if he does. I have nothing further.
Go ahead, Sting.
Judge, I obviously disagree with what they're suggesting. The 20 years is what's appropriate. That's why I capped it. He was habitual. And I went back and forth with this defendant multiple times throughout the pendency of this particular case, this evading. We had a trial date. From my notes, it shows that it was set July 10th of 2023, and I worked to resolve it then unsuccessfully. Same thing happened on October 9th of 2023, January 29th of 2024, April 15th of 2024, and then ultimately we reached this resolution on June 3rd of 2024. I mentioned that there's all that because while we're working to try to resolve that, I was going back and forth with numbers, looking at his 7-year sentence. At one point in time, I actually had the offer as low as 10 years, but that was before the accusations about the new drug offenses. And that's important because had this matter gone to trial, which I was prepared to do, I would have been looking to convince a jury of the habitual status of this man. I would have developed facts from the presentation of witnesses that for whatever reason, Beaumont chose to charge him with the evading as to the burglary of a habitation that was actually in progress at the time in which this offense began. You'll note from page 1 that the officers were responding to the victim saying, hey, I see a video where somebody's in my house. Whenever they get there, the people that were described are leaving in a car that was driven by Mr. Valson. It's obvious that that's the car and that Your Honor didn't get to see the video, but the TV that's stolen from the house is so big that they can't close the back door of the car where it's at. And as he's eluding the officers, that TV flies out and lands on somebody else's yard as the officers are working to try to place him into custody. So it's not this quote unquote, I panicked and where they got me at was right before I was at home. He may have almost gotten home, but there were blocks. There was quite a distance that this man traveled in his efforts to elude the officers that places him here. I highlighted during my examination of this man about the fact that he was on bond whenever he committed both sets of these offenses. Again, I was prepared at the trial of this matter to present evidence of both of these incident dates from February 5th of 2023 where the offenses are delivering in addition to the possession. It looks clearly apparent from the evidence of that. And I was going to present to the jury the theory that he was selling drugs at this time in which he was out on your bond, Judge. And it wasn't enough to catch his attention then that he ends up back in trouble, gets out on bond, and commits additional possession offenses, all of which I was prepared to present to a jury and suggest to them that we've got repeated offenses, totaling 8 while he's on. And those are the reasons why I believe it should be a 20-year sentence. When we look at page 6, I believe that the PSI officer agrees with me. I'm quoting, first sentence. It seems that the area of concern is selling drugs, and considering his lack of suitable employment, he will continue to do so. That is the very first sentence. So the probation officer agrees with me that this is a drug dealer that we got before us, and that if with his background, it's going to continue. Next paragraph. Based on the discovered findings, it seems jail time is not a deterrent for the defendant, though he has never received probation. Almost like defendants believe it's a right, which Your Honor knows it's not. Picking back up. It is obvious the defendant will never stop committing crimes. Those are her words, not mine, but I 100% agree with that. Therefore, completing probation successfully is poor. To date, the defendant has 9 felony charges and 2 misdemeanor charges pending. He has been in custody since he was a 13-year-old, starting at a TYC, and to go backwards, the state does not agree with.
Any follow-up?
What do you want me to say, Judge?
Anything you want to say?
Yeah, I mean, I'm glad that the state's been prepared for all these times, but it's still the fact of what do we do with him. There are options besides TDC, which who knows how long they're going to keep him. And he has not gotten probation. I've submitted some options that could really make it difficult for him if he doesn't straighten out his act with this court and with his track record. But his history is his history. He's been incarcerated for 15 years out of his life of 32. And he's out the street.
And here we have 9 felonies.
Mm-hmm. So that was the reason why I gave the recommendation or the option to the court, because somewhere the strain has to stop. And it's not going to stop in TDC. But for over a period of time, with the 25-year to life, in which probably would be justified, not the minimum of 25 with this record, because I don't think a jury would probably give him just 25, but he's looking at 30, 40 years if he comes back in front of you, justified with what's on this paper. So, I mean, and you got to wonder what parole was doing, releasing him early with his track record. And that's another whole different subject and field.
Let me ask the question. That's the big elephant in the room. What is it probation? What do you envision probation could do based upon the circumstances of these offenses? What is it they're going to do?
Well,
Nobody says he's got a, who says he's got a drug addiction? I mean, he's a drug dealer.
well, even
He's a
to
drug
this,
dealer. What's probation going to say? Don't do that.
well,
You don't do that. He knows that his mistakes have consequences. He knows that from his rich criminal history. He's been punished 3 separate times, felonies. So here we are with 9 new ones. What's probation going to order or offer that he hasn't been subject to? And it's just choice making. He is elected to make the bad choice between the 2 choices in a consistent fashion.
I can respond to that.
Go ahead.
They did do a drug assessment on him, the screening. and basically says that no, he may not have a drug problem, but if he tests dirty, then they would need to address it. My point is, though, Judge, is that they did make recommendations, and it is a long road to hoe in the sense of that if you're looking at, and he may not be smart enough to realize that if you're looking at 25 to life in front of you, I would recommend then that he has to go to do ISF. And then after that, he'd have to do the moral therapy. And then the drug behavior program after that. And all along, if he decides that he just doesn't want to listen to probation, then he's looking at the 25, and I would say probably not the 25, the 30 plus years incarceration in front of this court. And he's got to do it. I don't foresee an early termination, but he's going to have to do it for the next 10 years.
Your time, if you want to say anything. This is your life, sir. Go ahead.
Yes, sir. I would be very appreciative, if I was able to see probation. Like I told you before, I got a newborn daughter, I got my family, I got a wife now, I got an actual family now instead of me just being by myself. I got a family, step kids,
Wait a second. Don't you have a 13-year-old child?
Yes, sir.
Well, you've had a family for 13 years. You're now all of a sudden, you find it important. Don't hide behind a family.
Right.
You've had a family for 13 years. Don't say that the family is important to you now. My goodness.
And it's not different.
I think this is the first time they've
Yeah.
lived as a family, Judge. I think that's what he was trying
It's
to
not
say.
different.
It's his choice.
It's not.
He fathers the child. Every parent has a choice to make.
It's wrong, but it's different. Okay, I was incarcerated when she was born. Right before she was born, I did 5, came home, and she was already.
Why were you incarcerated? For something you chose to do
Yes, sir. No,
wrong.
it was all my fault.
Okay,
But it's just, I'm saying, it's my first time ever.
let me just,
No,
let me just interrupt you because I have experience as a father. I mean, I'm a grandfather now. But I can guarantee you that looking into your child's eyes, if you're doing this correctly, when you make choices that could be right or wrong, you think of not only what it would result in harm to you and the result to you, but I always thought of what my actions would do that would affect my children. Because you have chosen to do what it takes to be a parent. And you're supposed to act like them. What's the greatest gift you can give your child, by the way? What's the greatest gift? Good example. They're going to do what you do. It's a natural phenomenon. It's the way nature did
It's
it.
true.
Well, what kind of role modeling are you doing?
Bad.
It's worse than that. It's atrocious. If there's another word worse than that, I'd use it. But it's terrible.
That's what
You've had children. You've been incarcerated several times. Most of your life. You know that it has consequences. These new offenses, they're grand jury indicted, and that's probable cause to believe that you did wrong. You hadn't been found guilty of these, but you know what's in here? Death, fentanyl, which is death, phencyclidine, which they embalm animals with that. PCP. We have people here who are on PCP and they're absolutely crazy. They've lost their minds with phencyclidine. But you know that. I mean, these are actions that you're taking, according to the grand jury, after you've been subjected to punishments over and over and over again. It's a consistent pattern. And you've been given opportunities. With all of this, you were a free man. You were released. You had a family to turn to. you had, uh, you have an education, you have a GED equivalency, so you're capable of making intelligent choices when you want to. And then it says unemployed because you're unemployed. We all know what's going on here. You're making a living off the grid. You've decided to go to the dark side and make a living that way while your children are at home somewhere, while you have responsibilities, while you have been punished over and over and over again for bad choices. And I'm looking at nine new cases here. One here and before me that just tells everything about your life with these 3 prior felony convictions and this new case you pleaded guilty. No. Probation, the equivalency of what probation can do. You have been with this. You've had experience in opportunities to correct. And I'm about to assess a decision here, and I feel sorry for the children. I do. Just like we had the trial this week with a child sexually alleged to have been sexually assaulted and by her father. You feel sorry for the children. I don't feel sorry for you. You have had our Creator gives us opportunities and tries to help us. I believe in that. And you were blessed with children, responsibilities. You ignored those. You were sentenced, released, sentenced, released, sentenced, released. You have ignored the revolving door that you have put yourself in. You won't get out of it. And here we are with 9 new felony cases. And then this serious case, which puts the court in a bad position of really not having a lot of options. But it's your choices. This is a result. Your choices, just like everybody else who comes here. I just wished you would somewhere along this line here about to enter into your another felony conviction here you're staring at, which would be your 4th one, along with your numerous misdemeanor convictions. I just wish somewhere earlier you would have just resolved yourself to making the right choice. Some people just aren't intelligent enough to figure it out. You are. You know better. And you have blessings awaiting that you are just ignoring and hurting. I mean, that your children are going to, when asked, where's your father? What are they going to say? Anything else? This is just, I hate being put in this situation, because I want to give people a fair opportunity to fix their mistakes. You've had it in the past. And this is, you can't deny this. This has no explanation for it, except you chose to make the wrong choice when you knew better. All right, you pleaded guilty in paragraph 1, true in paragraph 2 to the prior aggravated assault with a deadly weapon conviction from 2011. This constitutes in this indictment a 3rd-degree felony enhanced to a 2nd-degree felony punishment. You have pleaded guilty and true respectively to paragraphs 1 and 2, these two crimes, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the plea hearing to find you guilty of paragraph 1 and true to paragraph 2. I hereby find you guilty beyond a reasonable doubt of paragraph 1 and true beyond a reasonable doubt. You were previously convicted of that, which constitutes this third-degree felony enhanced to a second-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years. I'm following this agreement. Now, there's good and bad about this. There's really nothing good, but there's light at the end of the tunnel. Is that it's not like the case before, one where you're not parolable until 1/2 of your term of sentence is passed. You were parolable in a quarter of your term. That's still a long time. I'm not sure how much credit you have right now. I don't think it's a lot, but it is a combination of the circumstances of this case and your rich, consistent criminal history that puts this court into a position of making its call, which I am concerned about, and being fair. There aren't a lot of options here. And the fact that you're not looking at a 25 to life sentence is a remarkable achievement on behalf of you by your attorney, because like we say, you were a habitual felon 2 convictions ago. Back in 2000, as far as 2021, you were a habitual felon. And when you committed that offense with the 2 prior convictions out of 2011 and 2017. So you committed that. Then thereafter, that was final. You commit this offense. So this is the second time you've been subject to habitual offender status, 25 times. So it's time you made the right choices from here on. It's still enough time in your life to fix this and also share your life with your family. But you need to make the right choices, not only for yourself, but for the responsibilities that you've been given by our Creator. Is there anything else? We got all of these other cases. What's the plan?
I'll work it out with the state. Just give me a time, maybe we can get finished today.